Welcome back. I fully intended this segment just to talk about the significant decisions, and they were very important in this recent Supreme Court session. But of course, all these rulings come in the backdrop of this shocking resignation that we got today. Justice Kennedy announcing his retirement at the end of July. Let me bring in constitutional law professor from Pace, Emily Gold-Waldman. She joins me now. And again, I'll get to the cases, but wow.
I feel the same way. Yeah.
Well, how will history look upon Kennedy in that he was the 5 and the 5-4 a vote more often than not, but also I think it's fair to argue he was the most significant or vital vote that we've seen in the last 20-something years in the High Court?
I completely agree. He was one of the most powerful, influential Supreme Court justices that I think we've ever seen. I mean, he was the 5th vote in so many cases, sometimes siding with one bloc, sometimes siding with the other, but he was the deciding vote.
And what I think made him such an interesting jurist is you didn't know before the case started where he would go. Certainly you didn't even know from oral arguments a lot of times where he would go. But I think it's fair to say that on the social issues, whether it be on affirmative action, obviously same-sex marriage, abortion rights, even though he was nominated by a Republican president, he would fall on the side of personal freedoms.
Yes. That was a big thing for him, was a number of his big decisions were joining up with what you might consider the Supreme Court's more liberal wing. So most recently in Obergefell, right, the same-sex marriage case, marriage equality. Yep. He joined with those 4 justices to write the decision. In 1992, it really seemed like the Supreme Court might overrule Roe versus Wade, and he joined with 2 justices who have already retired,
yep,
Sandra Day O'Connor, David Souter, to write this plurality opinion in a case called Casey, upholding Roe.
You know, in many ways, this recent session was Exhibit A in terms of Kennedy, his legacy, and sometimes the conflict he showed between trying to straddle both sides. Certainly an eventful most recent session, and that was before the bombshell of today. In just the past week, the Supreme Court upheld the president's travel ban, which we'll talk about in length in just a moment. It struck down a California law that required anti-abortion clinics to notify women that they could get the procedure at little or no cost elsewhere. Court also dealt a major blow to public sector unions by saying dues were not mandatory for workers, and it upheld electoral districts in Texas that were deemed discriminatory. So if you're noticing a pattern, you're not alone here. Every case siding with the conservative position. This has been a sharp right turn here that the court has taken. The starkest example, probably most significantly, that travel ban. In a 5-4 ruling, the High Court upheld a ban that 2 prior courts had already smacked down. They had used the president's own words as to his intent behind it against him because he was going around saying things like this on the campaign trail.
Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what the hell is going on.
By the way, so you don't have to divine where he was going, that was a prepared written statement. Anyway, Justice Sotomayor, she wrote a scathing dissenting opinion in this 5-4. Here a portion of it, quote, "The United States of America is a nation built upon the promise of religious liberty. Our founders honored that core promise by embedding the principle of religious neutrality in the First Amendment. The court's decision fails to safeguard that fundamental principle. It leaves undisturbed a policy first advertised openly and unequivocally as to, quote, total and complete shutdown of Muslims entering the United States, end quote, because the policy now masquerades behind a facade of national security concerns." And there have been countless articles and editorials blasting that decision in this recent session, as well as the direction now of the court under Chief Justice Roberts. Here a portion of an opinion piece from Bloomberg. Quote, "Roberts' opinion focuses mostly on the Immigration and Nationality Act, which gives the president the authority to exclude foreigners if he finds that their entry would be detrimental to the interests of the United States. Yet to focus on Roberts' analysis would be to make the same crucial error as Roberts himself has made. That is, treating one of the most outrageous acts of presidential bias in modern U.S. history as though it were an ordinary exercise of presidential power taken by an ordinary president acting in good conscience. The decision will be a stain not only on the legacy of the Roberts Court, but on that of the Supreme Court itself. And a lot of people are drawing a parallel to a very recent decision here, that being the Masterpiece Cake case. Now, the court in that case sided with that baker in Colorado who refused to make a cake for a same-sex couple due to his religious objections. In the case, the justice said the Colorado Civil Rights Commission may have had a discriminatory attitude towards the baker's Christian's beliefs. And that was one of the reasons why they ruled in that baker's favor. So again, Justice Sotomayor says, what's going on here? And she cited that in her dissent when it came to the travel ban. Quote, unlike in Masterpiece, where the majority considered the state commissioner's statements about religion to be persuasive evidence of unconstitutional government, the majority here completely sets aside the president's charged statements about Muslims to be irrelevant. That holding erodes the foundational principles of religious tolerance that the court elsewhere has so emphatically protected. Now, she also goes on to compare the travel ban to the Japanese internment camps during World War II, saying, as here, the government invoked an ill-defined national security threat to justify an exclusionary policy of sweeping proportion, as here, the exclusion was rooted in dangerous stereotypes about a particular group's supposed inability to assimilate and desire to harm the United States. As usual, Justice Kennedy, he was the swing vote. But in this case, he went with the majority and with the conservative wing of the bench. But still, Kennedy, as is his wont, raised questions when he said yes. And the questions were about presidential power. Here's what he said. There are numerous instances in which the statements and actions of government officials are not subject to judicial scrutiny or intervention. That doesn't mean those officials are free to disregard the Constitution and the rights it proclaims and protects. It is an urgent necessity that officials adhere to the constitutional guarantees and mandates in all their actions. So, he kind of wanted it both ways there, where he wanted the president and the government to look out for everyone, but yet he gave the benefit of the doubt to then candidate Trump, and I'd argue even President Trump with what he said, and he held basically a local official or officials in Colorado to a higher standard than he did the President of the United States with the cakes versus the travel ban. You're the attorney here, I'm not, but this was tough to follow the logic.
Yeah, okay, so I'll say a few things. First of all, what I think is interesting actually about all of these decisions is, as you said, Kennedy was in the majority and it was with the conservative side of the court. So in that way, actually, replacing Kennedy would not change the outcome
in this
of
particular
the case.
session.
Yes, in this particular session, more than some previous sessions, for example, the one with Obergefell, the marriage equality case, where there you could actually see a change. These decisions all, whether it was Kennedy or assuming a replacement by President Trump, they'd probably come out the same way. If you remember when that Masterpiece Cake Shop case came out, some people said, oh, this is a clue that now they're going to have to rule against Trump because if those statements make such a difference, it's going to cut that way too, and it didn't. I think that the majority of justices, at least, were a little bit unsure about, well, where would that leave us now? So if we say the president, because he has said these things in the past, now can't engage in these sort of foreign policy decisions, I think that they felt held back, that if they said that, it would be, and I'm not defending it, but I think that was their
But they divined intent in Colorado.
Right, and they did here too, and then they just said, but we're going to put that aside. It wasn't like they even
But the argument was in Colorado that an authority exercised his or her perceived bias.
Right.
And so how can you not hold that same standard to a person with the highest elected office in the land?
Yeah, I know, but I think that was almost part of their concern. If you saw one of the things Justice Roberts, who wrote the opinion, said was, well, we have to think about the office of the presidency itself, not just this president.
If I take this to, I believe, and who knows, the exact situation will present itself, but the limits of presidential power, at least in my lifetime, I don't see the likelihood like we see today, where this president, whether it be through an investigation into himself, his administration, or his campaign, has threatened to do actions that certainly wouldn't have co-equal branches of government in its application. Are they saying with the travel ban here that presidential powers, I know Kennedy said they're not unlimited, but they didn't make clear where they start and stop.
Right. And even Kennedy, if you saw, he said, well, there may be some times where we can't take action, but we still hope that the other branches and the president will live up to their own constitutional obligations.
And as the general public, we say, you pretty much have been the final backstop for us. If the court won't do it, who will?
And they said, we're not going to do it. They said, as long as on its face, you know, it's neutral and there is some sort of rational basis, we're not going to look behind. Even though we know what the intent was, he said it. And it's very contrary to what usually happens in constitutional law.
Simple math says 6-3 is much different than 5-4, and especially when that 5, you weren't sure in the past at least where that fifth vote would go. Potentially here, this could be as seismic and as significant as anything has happened in the Trump administration. As we said, a lot to process here and a lot that can happen between now and November or whenever they choose to have the vote, which I know they intend to do before the midterm elections. Emily, as always, thank you so much.
Sure.
Okay, coming up next here, this would have been our lead tonight here, but politics, it was a major night last night with a major upset in the state of New York, and it could have national implications for Democrats. Andrew will join me after this.